Hello everyone, I'm very pleased to be speaking to this conference, which is coming at a very important time in the law and particularly in developments of human rights. My name's David Cobb. I've been a lawyer for just over 40 years, and for the last 23 years I've been an advocate. I belong to the Arnot Manderson stable, which, in accordance with our long-standing tradition of 4 or 5 years, is the largest full-service stable in the Faculty of Advocates. For the last few years, I have been very heavily involved in matters such as adults with incapacity, but one way or another I've been involved with the mental health field for about 35 years. Now, we are at a particularly important point, which I hope this talk will illustrate and will help the discussions you have later in this conference. We're all human. We all have human rights. Human rights are universal and can be exercised by all of us equally. Can they? That is a far bigger and more difficult area, and one where at least a couple out of those first 3 statements may well be contested vigorously by many who have attended today. During this talk, I will of course touch on the Human Rights Act 1998, which was the first formal incorporation of the European Convention on Human Rights, which the United Kingdom had signed in 1951. Alongside that, the Scotland Act 1998 applied a prohibition of the Holyrood Parliament, put very broadly, or Scottish ministers and public bodies acting contrary to the established convention rights or passing laws which contravened human rights. One well-known example of that, which it is good to keep in mind in this discussion, is the successful challenge made to the Named Person Scheme set out in the Children and Young People Scotland Act 2014, which ended up in the UK Supreme Court. As a result of that challenge, parts 4 and 5 of that Act are, quote, not law, unquote, and attempts to rectify its shortcomings have proved unsuccessful so far. Closer to home, I think most of you will be familiar with the Adults with Incapacity Scotland Act 2000, which was probably the first attempt by Holyrood at passing a major piece of legislation framed by the human rights considerations I mentioned. Even more substantial is the Mental Health Care and Treatment Scotland Act 2003, of which we will hear more. We also have the 2 additional support for learning Scotland Act 2004 and 2009. There is the Adult Support and Protection Scotland Act 2007. Then, in 2010, the UK Parliament passed the Broad-Reaching Equality Act. We also have the 2 additional Support for Learning Scotland Acts 2004 and 2009. There's the Adult Support and Protection Scotland Act 2007. And then in 2010, the UK Parliament passed the Broad-Reaching Equality Act 2010. Disability is, of course, a protected characteristic for the purposes of that Act. Now, you could imagine a dry-boned lawyer telling you that all the law you want is there. What you have to do is apply it. Not so this lawyer, nor many of my counterparts, nor I imagine many of you. There is much that is in need of repair and improvement if persons with forms of mental disability are to enjoy anything resembling true equality with the fully able. What is the current background? I'll start this talk with a short tour d'horizon of the existing law, particularly the human rights elements, and consider where, for all the extensive provision that exists, it is either outdated or inappropriate to groups such as those on the autistic spectrum. I'll then consider the ongoing review of mental health law under John Scot QC and the potential influence of the recently published independent review of mental disability and autism in the Mental Health Act, better known as IMRA, and you'll be hearing from Simon Webster, who was a full member of that review team, and then look at the United Nations Convention of the Rights of Persons with Disability, the Uncrpd, and the law which may emerge in future, albeit I don't expect that to happen for a few years. Now, as a trustee myself of the mental health advocacy charity Partners in Advocacy, I don't lose sight of the compelling need for service users to have a voice in any reforms, and also how these operate in future. I think other speakers may have more to say on that, and it is encouraging that the Scot Review has drawn on evidence taken from lived experience and includes service users amongst its membership. In my view, the possible prize is a reformed legal regime which properly recognises the individual's wishes and preferences and adjusts to fit these. With that would come a rebalancing of the authority of the service user and the professionals. But where are we at the moment? What's wrong with the present law? Well, we can look at this in several ways. One analysis might simply reflect on the passage of time. In the case of the European Convention, for example, the general prohibition of deprivation of liberty is specifically set out in Article 5.1e to embrace detention of, quote, persons of unsound mind. Now that term may have reflected the thinking and the assumptions of psychiatry and psychology 70 years, remember, 70 years ago, but that language is clearly archaic and a blunt instrument. Yet there appears to be no appetite amongst the member states of the Council of Europe for updating that wording. In fairness, the Strasbourg Court, embracing its description of the Convention as a living instrument, has tried to reflect more modern thinking in this field through its case law. In particular, it has increasingly recognised that individuals with what could be broadly described as a mental disability have a, quote, particular vulnerability, which in some cases behoves the state to go an extra mile in protection of their human rights. As instruments of good intent are concerned, such language may seem unexceptionable, but as I will come on to discuss, that approach may conflict with the way in which the rights of disabled individuals are conceptualised and exercised in modern human rights terms. In particular, it may seem to imply that such rights can be most strongly exercised on behalf of such individuals rather than by them. What we also have to remember is that almost any form of intervention or restriction of activity which the state imposes probably engages the article right of freedom of private and family life. What many of you will also know is that there are many qualifications made to that right, and inevitably we encounter the wide-reaching get-out-of-jail card of Article 8.2, where the state can essentially prove that any measure it imposes is proportionate. Article 14 of the European Convention prohibits discrimination in enjoyment of human rights created by the Convention on a number of grounds. To modernise, the absence of the word disability may be a startling admission. Again, however, the living instrument approach resulted in the Strasbourg Court accepting from about 2009 onwards that disability fell within the catch-all other status mentioned in Article 14. Now, another arguably over-narrow use of language is found in Section 328 of the Mental Health Care and Treatment Scotland Act 2003, where the term mental disorder, a key phrase in the mechanics of the legislation, is defined as being, and you see it on the screen there, and I've emphasised the words learning disability, however caused or manifested. Now, as you may know, this section also goes on to tell us several things that a mental disorder is not. None of these refer to autism, meaning that legislation does not distinguish it, and particularly orders which can be made under this Act, from conditions such as schizophrenia, acquired brain injury, or intellectual disability. I will mention, and doubtless so will other speakers on this course, that the resulting conflation is both arbitrary and discriminatory against autistic people. I will consider in broad detail what the Rome Review, for one chapter of which I acted as an advisor, proposes in order to put this right shortly. It's important to appreciate, however, that the impact of the term mental disorder runs beyond the 2003 Act. For example, it also washes through to the forensic side via the Criminal Procedure Scotland Act 1995, with the result that orders which can be made there, which equally can result in a detention in hospital, may apply to persons with autism. In all, the definition of mental disorder is used in around 25 pieces of current legislation. The part of the Rome Review with which I was involved noted that the period of detention which arises will, in some cases, far exceed the time any mainstream disposal might impose. Such outcomes are clearly inequitable and discriminatory, yet our human rights compliant legislation effectively sanctions that outcome. Others might question the accuracy of the tests in the 2000 Act and also the additional support for learning legislation in obtaining effective and appropriate outcomes for autistic people. As I will mention, the use of capacity-based assessments arguably should and will be consigned to a different and archaic era in time. To my mind at least, it's remarkable that we in Scotland have now gone more than 20 years since the decision of the Strasbourg Court in Bournemouth, without legislation being enacted to regularise the deprivation of liberty of an incapable adult. As most will know, Bournemouth prompted the UK Parliament to enact the DOLS for England and Wales, which will be replaced in April 2021 by the Liberty Protection Safeguards. The fact that the DOLS were a supreme example of a gold plating of law, which resulted in an inoperable and often ignored process for authorising a deprivation of liberty, does not excuse Scotland for allowing a vacuum merely to linger. Reliance is placed, it seems, on Section 13ZA of the Social Work Scotland Act 1968, and as recently as this month, the Scottish Government acknowledged the conflict with human rights in the fields I will mention, or else reliance is placed on a carefully drawn guardianship order by way of creating a necessary authority for detention. This shortcoming became the more acute following the wide definition of deprivation of liberty given by the UK Supreme Court in the Cheshire West cases, including Lady Hale's ringing declaration that a gilded cage is still a cage. The Scottish Law Commission examined the position during the 2010s, leading to its report 240 of October 2014. I repeat, October 2014, which made detailed proposals for authorising forms of deprivation of liberty. In response, however, the Scottish Government did not propose any legislation, and for now, the law, as in other areas, remains unsatisfactory. In the course of this year, the absence of activity has been criticised by the Scottish Parliament's Equality and Human Rights Committee. It sometimes is described as a blind spot, with particular reference to the discharge of incapable adults from hospitals to care homes which took place during the early parts of the epidemic. I understand, in fact, that litigation is in process against Glasgow City Council by the EHRC regarding such instances, and that a breach of Article 5 has already been acknowledged to have occurred. I myself am involved in litigation concerning the apparent deprivation of liberty of a teenage girl at a specialised care unit. At present, however, there is unlikely to be any significant movement towards rectifying the breach in legislation. For individuals with a more severe manifestation of autism, for their families and for their carers, that is a highly unsatisfactory position. It's also remarkable, I think, that the role of an advocacy service established by statute in the 2003 Act currently is not repeated in the 2000 Act, as also is the failure of having a process to terminate an unlawful detention. Many might argue that this important role is being ignored or bypassed by professionals, and it should be noted that additional support for learning cases going before the first-tier tribunal only very recently gained access to advocacy services of right. What I think this analysis shows is that the apparently extensive range of rights available to individuals with autism has gaps and shortcomings. Those of you having lived experience will probably be less than surprised to hear that. Will the future offer a better prospect then? This takes us to the Scot Review. Now, in some respects, the Scottish Government may have a significant excuse for the progress of reform. Certain piecemeal reviews have been undertaken, including one relating to the 2000 Act, and also the Rome Review with its particular focus on learning disability and autism. There is also an additional support for learning review, which reported in June 2020. And for completeness, the Barron Review of the Delivery of Forensic Mental Health Services very recently issued a troubling interim report and is due to release a final report in January 2020. However, in September 2019, the Scottish Government announced that it was commissioning a review of the whole body of mental health legislation. I'll say later that that itself may be a controversial term, under the chairmanship of John Scott QC. Now, aside from the Chair's own distinguished human rights record and his chairing of other inquiries and reviews, he has available to him the likes of Colin Mackay, the former Chief Executive of the Mental Welfare Commission, Professor Jill Stavert of Napier University, and as I mentioned previously, the lived experience of a number of service users. Now, amongst the terms of reference of the Scot Review are what I've set out on the slide. Now, again, emphasis on the highlighted bits, improvement of rights and protections, focus on mental disorder, and specifically in the bottom part of this slide, mental health, incapacity and adult support and protection legislation with reference to the Uncrpd and the European Convention. Further, there is reference to highest attainable standards of mental health, reference to equality and non-discriminatory enjoyment of rights, and you can also see the various raft of people who potentially impact on experience of mental health and other laws, and there is a reference to patient experience also. And finally, it looks at issues such as the gateway to compulsory measures, that is orders and sometimes detentions, and also questions the continuation of the use of capacity and the significantly impaired decision-making ability test, the SIDMA test, which appears in both of these pieces of legislation. Now, I stress there's a lot more in the terms of reference which I've left out, but these seem to be the most relevant to the discussion which we're having. So, the Scot Review has its own website. I've given the address. It publishes a monthly newsletter. It issued an interim report in May of this year. It's scheduled one for December. And a final report will probably appear at some point in 2021. The timetable is liable to be impacted by the past and future effects of the COVID epidemic. But I hope that this talk, if it achieves anything, helps you shape your responses to their proposals, along with the other speakers which you will hear from. What I think also needs to be understood, though, is that nothing this review proposes prior to the Holyrood elections in May 2021 has a prospect of reaching the statute book immediately. Moreover, no assumptions can be made how the next Scottish Government will actually deal with the report. And typically the Scottish Government responds to such reports prior to initiating a further period of consultation. That's what's happening with the additional support for learning review. And possibly cover consultation will follow in draft legislation, and that's before anything gets near the floor of the Scottish Parliament. For reasons that I move on to outline, some of the changes likely to be proposed may meet considerable political opposition on account of a fundamental change of perspective towards vulnerable groups, which is likely to be proposed. So let's move on to the Uncrpd, the United Nations Convention on the Rights of Persons with Disabilities. This was signed by the UK Government in 2007. The Scottish Parliament passed a motion supporting incorporation of the Uncrpd in 2016, and the Scottish Government has adopted a strategy for incorporation of the Uncrpd covering the period, I'm sorry the slide has a slight typing error, 2017 to 2021. That, however, falls considerably short of implementation of the Convention in any substantial sense. Last month, some of you may be aware, the Scottish Government published the United Nations Convention on the Rights of the Child Implementation Scotland Bill. The approach taken there is one of simply adopting the full text of the UN Convention on the Rights of the Child and essentially requiring Scottish ministers and public bodies to abide by it, and that is broadly the same manner as applies under the Human Rights Act. Now that's an extremely short paraphrase, but as the articles of the Uncrpd I consider in a moment indicate, it's not seen as an approach which could realistically be adopted with the Uncrpd as a whole. As I mentioned later, some of its terms are sufficiently broad and ambiguous in some instances, and essentially defy enforcement in their own right as rules of domestic law. It's important to understand, firstly, what disability means in the case of the Convention. It's defined as being, as you can see in Article 1, long-term physical, mental, intellectual or sensory impairments which in interaction with various barriers may hinder full and effective participation in society on an equal basis with others. And that is really bolstered by what is then described that the purpose of the Uncrpd is to secure the full and equal enjoyment of all human rights and fundamental freedoms by persons with disabilities. In the time available, I can't go through the Uncrpd article by article. Tom Kirkwood has helpfully prepared a slide for his talk which lists all of these articles. Instead, I'll look at a few key provisions which may be the benchmark of whether Scotland's law has achieved the overall purpose I've just described. One key part of the Convention, crucial I would suggest to what may emerge from Scot, is Article 12, part of which states that, and again we look at right to recognition, enjoyment of legal capacity, and support to exercise that legal capacity. Then there is perhaps the very nub of this provision. It talks about the exercise of legal capacity, but it also talks about safeguards. It talks about respecting the will and preference of the person, avoiding conflict of interest and undue influence, and also that any controls are proportional, tailored to the person or shot, and also that there is a review by some body, whether it be a judicial body or an impartial authority, and it's proportional to the degree of the impact on the individual's right. What's that mean in practice? Well, there are many takes on that. One example could be the more light touch form of guardianship proposed by Sandra MacDonald, the former public guardian. She's proposed a three-tier model which potentially could reduce the involvement of the sheriff court or similar body. If that happens, are these cases then subject to regular review by an impartial body or a judicial body? On another view, we could move to a significantly enhanced supported decision-making regime of the kind considered by the Scottish Law Commission in its report. By contrast, the view of the UN Committee on the Uncrpd is that Article 14 outlaws any substituted decision-making as discriminatory against persons with a disability. This last conclusion does not have a wide constituency generally, and little if any in Scotland. The legislative solution adopted undoubtedly will try to find a bright line between those who cannot practically exercise decision-making capacity, such as those on a PVS, yet recognising that persons with a disability arguably should have the freedom to make the same mistakes or to take bad decisions in the same way as the fully able currently do. Nevertheless, Article 14 clearly gives scope for a range of protective checks and balances affecting a number of issues. Beyond that, others point out that it's too narrow an approach to see the Uncrpd as merely embracing decision-making. The Convention can be read as addressing the legal agency of persons with disability, that is, the ability to exercise both rights and duties. Given what Articles 12.1 and 2 say, it is that legal agency which is to be exercised equally alongside the fully abled. This would extend to areas such as the ownership of property, the rights to vote and to marry, as three examples. It also begs the question of whether capacity-based assessments can lawfully operate in compliance with the Uncrpd. As I mentioned, disability is defined against interaction with barriers in society. Can a medical model really fit that definition? Let me turn to the matter of deprivation of liberty. Again, I've set out Article 14 of the Uncrpd, which mentions disabilities on an equal basis with others, enjoy the right to liberty, are not deprived of liberty unlawfully or arbitrarily. And going forward, so I'll just go back to that, any deprivation of liberty must be in conformity with the law, and that the existence of a disability shall in no case justify a deprivation of liberty. Now, the meaning of those highlighted sections, again, are highly disputed. On one view, the detention of an individual with a disability has been outlawed entirely. On the other, a legal process which authorises detention with appropriate safeguards might suffice. Apart from the failure of our current law to comply, in my view at least, with the Human Rights Convention, without becoming over-legalistic, Article 5 of the European Convention and Article 14 of the Uncrpd do not say the same thing. Fundamentally, that says deprivation of liberty of the person of unsound mind, inverted commas, can be lawful, whereas the Uncrpd says you cannot do that on the basis of a disability. And it's perhaps unfortunate that the Scottish Law Commission report did not really consider the Uncrpd when it made its proposals. It remains to be seen whether the idea of authorising a significant restriction of liberty can avoid falling between two stools. I think we all recognise that there will be cases where measures of this kind are unavoidable. The Strasbourg Court is giving increasing recognition to the Uncrpd in its recent judgments, and that may focus any solution proposed by Scot. But at this moment, Scotland has no regime which complies properly with either treaty, and this is a situation which cannot continue for the sake of all the relevant stakeholders. One change which has been advocated is a requirement to make a human rights assessment prior to the taking of any decisions involving an individual with a disability. We'll enlarge on that when I discuss the IMRHA, but the extent to which human rights established by both treaties could impact on that process may be more apparent. However, there's more in the Uncrpd. A third significant strand relates to the recognition of what are called the socio-economic rights of persons with disability. You remember that I summarised some of the more relevant legislation governing and conferring rights in this field, broadly speaking, of mental health. You will also have your own experiences of how these operate in practice, or they don't. It seems to me, however, that implementation of the Uncrpd goes some way beyond what currently exists in our law. For example, Article 24 establishes a right to an inclusive education system at all levels. Article 25, a right to enjoyment of the highest attainable standard of health, and Article 28, a right to an adequate standard of living. As the Rome Review points out, the European Convention only establishes minimum standards, and the phraseology I have quoted clearly requires our law to aim somewhat higher. These are, of course, pretty broad-brush terms. Does the right to education mean that all children should be mainstreamed? Does the right to independent living in Article 19 apply in both the public and private sectors? In practical terms, does the Article 25 right to health mandate the removal of the significant and persistent inequality of outcomes for persons with disability? One particularly sensitive issue will be reconciling the right to independent living with the extent to which the state, in its various forms, is able to control and restrict the activities of an individual. I stress that I don't pose questions like that for the sake of simply asking questions. The reason I ask them is for the purpose of stimulating consideration of what you might want from implementing these socio-economic rights in future law, and informing and responding to the Scot Review, which ultimately will be the starting point for reform. I accept there will be a range of views, and what I will have to say in conclusion is simply one of many. It remains to be seen to what extent Scot will run with the ball of socio-economic rights, or will leave that to other arms of government to adopt and implement. And coming on now to look at the Rome Review, I note that it recommends a new law to support access to positive rights, including the right to independent living. It may be asking too much for this process to prescribe how all of the Uncrpd is to be given effect, but there are several strands which seem integral to that outcome. So, the Rome Review, the IMRA. It is, of course, expressly relevant to those working in the field of autism. What I think you will all know is that Rome challenges the classifications of persons with learning disability or autism as part of the definition of mental disorder I talked about earlier, which also applies in both the 2003 Act and the 1995 Act. Rome has concluded that learning disability and autism should be expressly removed from that definition. It also commends adoption of the definition of disability provided by the Uncrpd. Autism will be based on a professional diagnosis of autism, and intellectual disability will be similarly founded. Individuals and their unpaid carers will be entitled to use whatever words they wish to use, as well as a system of human rights assessments underpinning a human rights-based system for all decision-making. Now, for as long as possible in this talk, I've been avoiding the use of the term paradigm shift. In the words of Rome, we are required to understand disability differently and embrace changes in culture, practice and the use of resources. I think we will all accept that is a material change of outlook from the process begun in 2000 with the Human Rights Act. I hope, however, that the human rights treaties I've told you about confirm that the Scottish Government already is bound to, and is promising to become bound to, obligations that place human rights and exercise by an individual with a disability of their legal agency, and gives and places explicit rights at the centre of future legislation. What might this mean? In Rome's view, there is work to be done before the necessary switch can be flicked. The review points to a number of fields in which those with autism or intellectual disability experience indirect discrimination, and that arises where equal opportunity of a law or policy disadvantages a group sharing a protected characteristic. I said earlier that disability is a protected characteristic, and it is unlawful to indirectly discriminate against someone who has such a protected characteristic. The lived experience described to Rome, and I'm sure seen to some extent by most of us here, strongly suggests that the 2010 Act alone is not producing proper outcomes for the group. To take a few examples, detention overall is applied for almost twice the duration it attaches to individuals who meet the same broad definition of mental disorder. And the same is true of unconsented treatments, which may include the delivering of antipsychotic medicines. Detention under a forensic order is also longer, according to MWCS data, than for those found to have a mental disorder, or those who have no mental disorder at all. In some cases, the period of detention potentially may have no realistic end date, given that the condition may not change, and support in the community may either be absent or inappropriate. Is that compatible with Article 14 of the Uncrpd? In the field of health, the existence of comorbid diseases amongst autistic people, around a third of those with autism, leads to earlier preventable deaths. This is demonstrated in significantly lower life expectancies and also significantly higher suicide rates among autistic people. This is partly the result of restricted access to primary and specialist health services. Is that compatible with Article 25 of the Uncrpd? The criminal justice system, which I'm more familiar with, may be both impenetrable and intimidatory for autistic people. The experience of a prison regime, and the same will be true of many hospitals, as the Barton Review has been finding, may be far more demanding. But equally, the process of being prosecuted or giving evidence as a victim of crime may be incomprehensible without appropriate support and adjustments. It's what Rome describes as a lack of visibility of the human rights. You'll find that Article 13 of the Uncrpd has something to say about access to justice. But does Scotland really fulfil the requirement as the law presently stands? I could quite easily run through a checklist of various Uncrpd articles and say where our current law falls short. I'm sure that speakers and participants will fill much of that space with their own knowledge and experience. Suffice to say that Rome recommends that a new law is introduced specifically to protect and promote the rights of autistic people and people with intellectual disability. Rome's careful to point out that the intention is not to discriminate against other individuals with a mental disorder, but to address the kinds of discrimination experienced by those with intellectual disability and autism, and to protect and promote their rights in this field. Overall, the review can see benefits for other areas of disability law generally. Whilst I acknowledge my participation in this review, these are in fact recommendations I firmly endorse. The Rome Review is a wide-reaching document, and we could devote the entire course simply to analysing what it says and proposes. Much of what it considers relates to the exercise of legal agency set within a human rights assessment, demonstrating the necessity and proportionality of any restriction the state wishes to place on such exercise. By contrast, the state should do all possible to promote such exercise of Uncrpd and other human rights. And it follows as a natural corollary that an enhanced role, described as full access, is specified for independent advocacy and for making a statement of will and preferences of a far greater weight than experience of making advanced statements has demonstrated. In essence, justification for a decision going against such a statement would require to be shown to be justified and proportionate in human rights terms. In essence, the model of supported decision-making, including statement of wills and preferences, is being advanced. I note in passing that similar arrangements are recommended for children as part of the implementation of the Rights of the Child Convention. This particularly bears on proposals for psychological interventions, where the default generally has been the individual making their own decision, subject to it being overborne only after a human rights assessment has been made. The same would apply to the prescription and administration of psychotropic medication. One other particular theme is the adoption of community rehabilitation for individuals with autism who have been in hospital or prison as a means of protecting their right to independent living and reducing limits on the right to liberty. This is regarded as particularly important for providing positive alternatives to admission to hospital and delayed release from prison or hospital. Will the Uncrpd change the law? Rome makes other innovative recommendations to improve procedures and practice in areas such as tribunals and courts and in professional training. If adopted, these could make a significant difference to the life experience of autistic people. Consider how the obtaining of appropriate and tailored schooling might develop if it's seen from the perspective of a right to an inclusive education, rather than having a dispute of the consequence of a capacity assessment. Consider the scope for obliging an HSCP to create a care and treatment based on the right to, quote, the highest possible standard of healthcare, rather than the minimum it feels it can provide. The same may be true of self-directed support given in pursuance of a right to independent living. The decisions of medical practitioners may need in future to be properly justified rather than authorised via a paper chase. Such changes would indeed be a paradigm shift in anyone's terms if they occur. The prospect of tackling inequalities and asymmetries would be a real one, and I suggest is possibly within reach in a relatively short period. However, one possible risk in my mind is that implementation of these kind of measures are simply peeled off from more substantive recommendations made by Scot and dealt with more or less rapidly and more or less fully by different arms of the Scottish Government. To my mind, such an outcome would disrespect the work which was carried out by the various reviews I've discussed and would not represent anything like a full and proper implementation of the Uncrpd into our law. As I pointed out, there seems to be no practical way of following the technique adopted for the Rights of the Child Convention, and I can imagine implementation of the Uncrpd becoming embroiled in turf wars if the primary premise founded on human rights is not embedded first. That would be to the detriment of autistic people and those with disability generally. I would respectfully suggest, therefore, that future strategies for autism should unashamedly and boldly adopt the human rights-based model advocated by Rome and by a number of academic commentators, and pursues this in any representations which it itself makes to the Scot Review. Where are we going? One small but potentially significant observation of the Rome Review was that the term mental health law might usefully be recast as law for mental health. That change of emphasis, consistent with the paradigm shift I have described, may well encapsulate the ethos of the Uncrpd and potentially the future direction of the law in Scotland. I say that because the phraseology frames the law in terms of accessible rights to mental health services for all of us, irrespective of the badge attached to a particular condition. Embedded in that is provision of services in a manner which does not discriminate against those with autism, and in a manner which is consistent with their human rights, irrespective of whether or not these are written in the European or UN conventions, or indeed both. It is precisely that which Article 5 of the Uncrpd, in talking about equality and non-discrimination, prescribes. Earlier on, I said that the possible prize of the Scot Review was a reformed legal regime which properly recognises the individual's wishes and preferences and adjusts to fit these. The point will come where people in your position, your partners, their families and their advocates have the opportunity to comment on the proposals the review makes. I hope that this talk and the contribution other speakers make to this forum will inform your responses. To conclude, we are at a significant turning point for the law which impacts on autistic people. I say that the building blocks potentially are there to make the paradigm shift affecting this group and other vulnerable groups in a way which makes equality and non-discrimination real and which can change their life experiences fundamentally. What I believe I've also shown is how previous initiatives have simply run into the sand to a greater or lesser extent and leave us with laws and services which are not suitable for the middle part of the 20th century. We are all human. We all have human rights. Human rights are universal and can be exercised by all of us equally. We have a part each of us to play in making that true for autistic people. Let's all make maximum use of the opportunity the Scot Review offers us to achieve that. I thank you very much for your attention, and I wish you a stimulating and successful gathering. Many thanks.